This is the fourth part in this series of lecture on this topic of Section 6 of the Hindu Succession Act. This Section 6 of the Hindu Succession Act was amended by the Amendment Act of 2005, and it came into force with effect from 9th September 2005. But before this amendment, what was the provisions contained in the old or earlier Section 6? We have to see it. So I read this earlier Section 6, that is before the amendment. The title of that earlier Section 6 is Devolution of Interest in Coparcenary Property. In that earlier Section 6, there were no any subsections. That earlier Section 6, it was divided into three parts. First part, that is the main provision giving the general rule. Second part to that Section 6 was the proviso clause, which is proviso to the general rule, that is exception. And third part is relating to explanation clause. What is the first part? When a male Hindu dies, after the commencement of this act, having at the time of his death an interest in a Mitakshara coparcenary property, then his interest in the property shall devolve by survivorship upon the surviving members of the coparcenary and not in accordance with this act. So this Section 6 makes provisions relating to devolution of interest, undivided interest of a deceased coparcener. So it makes a provision that when a male Hindu dies, which male Hindu having an interest in Mitakshara coparcenary property at the time of his death, then his interest, his undivided interest, shall devolve by survivorship. Devolve by survivorship upon the surviving members of the coparcenary. That devolution by rule of survivorship is the most important feature of the Mitakshara coparcenary system. So, supposing there are 4 brothers in a family, one of them died, then his undivided interest in the family shall devolve by rule of survivorship upon other 3 surviving brothers. So this is the general rule. Then there is a proviso clause in that earlier Section 6. It says, provided that if the deceased had left him surviving a female relative specified in class 1 of the schedule, or a male relative specified in that class who claims through such female relative, then the interest of the deceased in the Mitakshara coparcenary property shall devolve by testamentary or intestate succession, as the case may be, under this act and not by survivorship. So this proviso clause tells when that undivided interest of the deceased co-partner will not devolve by survivorship, but it will devolve by testamentary or intestate succession. For that, there is one condition. What is condition? When that deceased co-partner left behind him surviving any female relative which is specified in class 1 of the schedule. Class 1 of the schedule means it is a schedule giving the list of class 1 heirs. So when that deceased co-partner left him surviving any female relative specified in class 1, female relative, class 1 female relative, for example, that widow of deceased co-partner, daughter of deceased co-partner, or when that deceased co-partner left him surviving a male relative specified in that class who claims through such female relative. Male relative in that class means class 1 here, who claims through such female relative. For example, a son of predeceased daughter is a class 1 here. Daughter is also class 1, but suppose she is predeceased, then her son is also class 1 here. So this proviso clause says when that deceased co-partner left him surviving any female relative specified in class 1 of the schedule, then his interest in the property shall devolve either by testamentary succession or intestate succession, as the case may be, but not by survivorship. Means, suppose that deceased co-partner has executed a will for devolution of his undivided interest, then his undivided interest will devolve as per the instructions given by him in his will. And if suppose he has not executed any will, then his undivided interest will devolve as per the intestate succession, that is as per the rule of inheritance. So general rule says that the undivided interest of the deceased co-partner shall devolve by rule of survivorship. To this general rule there is exception. It says it will not devolve by survivorship, but it will devolve by way of succession, that is intestate succession or testamentary succession. But when he has left behind him any class 1 female relative, then there is a third part which is explanation clause, which says that for the purpose of this section, the interest of a Hindu Mittakshara co-partner shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before his death, irrespective of whether he was entitled to claim partition or not. Why this explanation clause is given? Because if suppose we have to devolve undivided share of that deceased co-partner either by way of testamentary succession or intestate succession, then firstly we have to find out the quantum of his share in the entire co-partnership property. How we can find out that quantum of share? So there is the explanation clause 1 it says we have to suppose that before his death there was a partition, and if suppose there was a partition immediately before his death, what share he would have got? What share he would have got? That is his share now for the purpose of devolution of his share by way of testamentary or intestate succession. So this explanation clause gives the concept of notional partition. Notional, it is a deeming provision. Why it is necessary? Because we have to find out the actual share of that deceased co-partner in the entire coparcenary property. So it says, supposing he had been alive and there was a partition, what share he would have got? That share is now his undivided interest. So this is a notional partition, and purpose of this notional partition is merely for the ascertainment of undivided interest of that deceased co-partner. So this was the earlier section 6 before the amendment. So previously, before 2005 amendment, although the widow or daughter could claim a share being a class 1 heir in the property left by the deceased co-partner, and even though a widow was entitled to claim a share in the event of partition, yet the daughter was not treated as a co-partner. Means under the proviso clause of that earlier section 6, those class 1 female relative like widow and daughter, they were entitled to a share. But which share? In the share of that deceased co-partner. They were not entitled to any direct share in the coparcenary property. And about the widow, in case of partition, widow also used to get equal share, and that share is in lieu of her maintenance, because all female members of the family having a coparcenary property, having right over the coparcenary property for their maintenance. So even though under the proviso clause such daughter was entitled to get a share in her father's share, she was not treated as a co-partner. So earlier section 6 of the Act deals with the devolution of interest of a male Hindu in a coparcenary property and recognizes the rule of devolution by survivorship among the members of the coparcenary. So that earlier section 6 recognizes the existence of the rule of survivorship, which is very important feature of the Mittakshara coparcenary system. The retention of system of Mittakshara coparcenary property without including the females in it means that the females cannot inherit ancestral property as their male counterparts do. The law, by excluding the daughter from participating in coparcenary ownership, not only contributes to her discrimination on the ground of gender, but also has led to oppression and negation of her fundamental rights of equality guaranteed by the Constitution. Having regard to the need to render social justice to women, the states of Andhra Pradesh, Tamil Nadu, Karnataka and Maharashtra have already made necessary changes in the law giving equal right to daughter in Hindu Mittakshara coparcenary property, even before this 2005 amendment made by the Union of India, central government. we will consider one illustration to understand what actually the difference results into by application of old section 6 and new section 6. Supposing there is a one family, joint Hindu family, consisting of father, his wife, two sons and two daughters. Suppose father has having ancestral property of 30 acres of land property, 30 acres. Suppose father died in the year 1990. In the year 1990, it means that the provisions of old or earlier section 6 would apply to his case. Now, suppose he died in the year 1990. Now, what the main provision of the earlier section 6 says? His undivided interest in the entire 30-acre land property will devolve by rule of survivorship. That is general rule. It will devolve by survivorship upon the surviving co-partners. But in our example, since he has died leaving behind him a widow and two daughters who are class 1 female relatives, therefore in our example the proviso clause of that old section 6 will come into operation. So as per that proviso clause, now the undivided interest of that deceased father will not devolve by rule of survivorship, but it will devolve by rule of either testamentary succession or intestate succession. Suppose father has not executed or made any will for disposing his property. In such situation, his undivided interest will devolve by rule of intestate succession, that is by way of inheritance. Therefore, now we have to find what is actually his share in the entire coparcenary property of 30 acres of land belonging to his family. For that, we have to take help of notional partition. Notional partition, suppose father is alive and they want to make a partition in the family. So how many co-partners are there in the family? Father and his two sons. That means father will get 1/3 share upon a partition. 1/3 of the 30 acres, that is 10 acres. It means that by way of notional partition, we have find out father's undivided interest in the entire coparcenary property is 10 acres out of the total 30 acres land. Now this 10 acres of the land property now will devolve by way of inheritance upon his heirs. How many heirs he left behind him? Class 1 heirs, his widow, his two sons and his two daughters. Means there are in total 5 class 1 heirs. So that 10-acre lands, which is his undivided interest, that will devolve upon those 5 heirs. It means that each daughter will get 2 acres out of that 10 acres of land. So by operation of provisions of old section 6, each daughter will get only 2 acres of land out of the total 30 acres of land belonging to their family. If suppose during the lifetime of father, if any son has claimed the partition against his father, then in that case each of these two sons would have got directly 10 acres of land. But because of the operation of old section 6, each daughter is entitled to get only 2 acres of land. But son, because they are male co-partner, they are entitled to get directly 10 acres of land upon partition. So it is clear-cut discrimination between sons and daughters. So this earlier section 6, provision of earlier section 6, it was causing a discrimination and injustice to the daughters. Now consider with this same example, consider the provisions of new section 6. Now suppose said father has died in the year 2010, that is after the Amendment Act of 2005. This new section 6 now says that daughter of a co-partner shall have equal right to that of the sons of the co-partners, meaning thereby after the death of father, his widow, his 2 sons and 2 daughters, each of them will get equal 1/5 share in the entire co-partnership property. So by way of example, we have considered that family was holding 30 acres land as a co-partnership property. So by application of this new section 6, amended section 6, each daughter will get now 6 acres of land. So see the difference. As per the old section 6, each daughter would have got only 2 acres of land out of total 30 acres. But because of the operation of new section 6, now each daughter will get 6 acres of land out of the total 30 acres of the land. And each son will also get 6 acres of the land. Widow of that deceased co-partner will also get 6 acres of the land. Thus there is a now equality between sons and daughters. Now it is necessary to read actual wording of the amended section 6, which was amended by Amendment Act of 2005. This amended new section 6 contains 5 subsections, but earlier section 6, it did not contain any subsection. Now this amended section 6 contains 5 subsections. The heading of the new section 6, it is the same: devolution of interest in co-partnership property. Subsection 1 is in the nature of declaratory form. Subsection 1 says, on and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family, governed by the Mitakshara law, the daughter of a co-partner shall, clause A, by birth become a co-partner in her own right in the same manner as the son. So clause A of subsection 1 says, a daughter of a co-partner shall by birth means by virtue of her birth in the family. The daughter of a co-partner shall by birth become a co-partner in her own right in the same manner as the son. Then clause B, the daughter of a co-partner shall have the same rights in the co-partner property as she would have had if she had been a son. So clause B says same rights that of son. If suppose she would have been born as a son, what right she would have got? That same right now she will got. So clause B of subsection 1 of this new section 6 says, a daughter of a co-partner shall have the same rights in the co-partner property as she would have had if she had been a son. And clause C says, a daughter of a co-partner shall be subject to the same liabilities in respect of the said co-partner property as that of a son. Means same rights, same liabilities as that of a son. This subsection 1 contains a proviso clause. What is that? Provided that nothing contained in this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before the 20th December 2004. So proviso clause says, so whatever disposition or alienation, including the partition of that co-partner property had taken place before 20th December 2004, it will remain unaffected. It will remain unaffected. So merely subsection 1 declares a daughter as a co-partner, those earlier disposition or alienation or partition will not become invalid. So this proviso clause saves all those earlier disposition or alienation or partition which had taken place as per then prevailing law and which are valid disposition or alienation. So it will remain unaffected. Then see the subsection 3 of this section 6, new section 6. Here a Hindu dies after the commencement of the Hindu Succession Act 2005, Amendment Act 2005, then his interest in the property of joint Hindu family governed by Mitakshara law shall devolve by testamentary or intestate succession as the case may be under this act and not by survivorship. So this subsection 3 says now that undivided interest of the deceased co-partner shall now devolve not by the rule of survivorship, but it shall devolve by testamentary or intestate succession. If we remember the provision of earlier section 6, the main part of that earlier section 6, it says that the interest of deceased co-partner shall devolve by rule of survivorship, and its proviso clause says that if suppose he had left behind him any class 1 female relative, then his interest will not devolve by rule of survivorship. So in earlier section 6 there was a precondition of existence of class 1 female here for not coming into operation of rule of survivorship. But under this amended provision, there is no any such precondition regarding existence of any class 1 female relative. This subsection 3 straight away says that henceforth the interest of the deceased co-partner shall not devolve by rule of survivorship, but it shall devolve either by the testamentary succession or intestate succession. Why such a provision is made? Because the rule of survivorship is the very basic and main feature of the coparcenary system, and it is a need of time. We have to abolish this coparcenary system because it was causing gender discrimination amongst between sons and daughters of the coparcener. So subsection 3 says that now the interest of the deceased coparcener shall not devolve by rule of survivorship, but it shall devolve by testamentary or intestate succession, and the coparcenary property shall be deemed to have been divided as if a partition had taken place, and the daughter is allotted the same share as is allotted to a son. That means for the purpose of devolution of interest of that deceased coparcener, when we need to cause notional partition for ascertainment of the share of that deceased coparcener, then in that case we must not forget to allot an equal share to a daughter also to that of a son while making such a notional partition. Therefore, this subsection 3 also carries the explanation clause which was the same as it was there under the old section 6. That explanation clause is regarding the notional partition, and it is for the ascertainment of the share of deceased coparcener for the purpose of devolution. Now we will consider the subsection 5 of this amended section 6. It says that nothing contained in this section shall apply to a partition which has been effected before 20th December 2004. So we have already considered the proviso clause to subsection 1 of this section 6. There also it is mentioned that whatever disposition or alienation or partition which had taken place before the 20th December 2004, it will remain unaffected. This subsection 5 makes this thing further clear. It relates to the partition. It says that nothing contained in this section shall apply to a partition which has been effected before the 20th December 2004. Meaning thereby considering that old example, there was one joint Hindu family which consists of father, his 2 sons, 2 daughters and his wife. Suppose before the death of the father, if any son has claimed the partition against the father, then in that case each son and the father each will get equal 1/3 share in the entire coparcenary property, and daughter will not get any share upon such partition. So suppose in our that example, that family was having 30 acres of total land as a coparcenary property, and in that family, father and his two sons, means there are total 3 co-partners, and upon partition each son would have got 10 acre out of 30 acre, but daughter would have got nothing because she was not the co-partner. So if said partition had took place before the 20th December 2004, then it will remain unaffected. So after coming into force of this amended provision, that is after commencement of this amended provision, now daughter will not say that, since because we are also co-partner, we want to cause partition again. No, partition had already took place. If the partition had already took place, then it will remain unaffected by these new provisions. So, but here whoever is contending that in our family we had already partition, they have to prove it, and for the purpose of evidence, this subsection 5 contains one explanation clause. What is that explanation? For the purpose of this section, partition means any partition made by execution of deed of partition duly registered under the Registration Act, or partition effected by a decree of a court. So, for the purpose of evidence, only 2 modes of partitions are recognized. First is which is effected by duly registered deed of partition, registered deed of partition, registered under the Registration Act. And another mode which is effected by a decree of a court. In supposing any co-partner had filed a suit in the court against another co-partners or other co-partner for partition, then in that case the decree of partition passed by the court is considered here as a proof of partition, and no any other mode of partition is recognized. Regarding this aspect and regarding this date, 20th December 2004, I will explain this point further in my next part of the series of lecture on this topic of interpretation of section 6 of Hindu Succession Act.